Okay, so hey everyone, and welcome back to another episode of Default Global. This is where we connect with global first entrepreneurs and remote work experts from all around the world. And our guest today is Tara Vasdani, managing partner at Remote Law Canada. Tara, thanks for joining us today.
Thanks for having me. I'm super excited to dive deep into some of these topics.
Yeah, absolutely. Tara, as a founder of Remote Law Canada, a law firm that's specializing in remote work, right? I would love to hear more about your journey. Can you briefly walk us through how you became interested in remote work and what inspired you to create a law firm that is exclusively focused on remote work?
Absolutely. So, it's sort of an interesting story, but it makes for good content. So I'll let you guys know. As an employment lawyer, I was obviously always curious about the way that employment laws apply to different types of employees. That happened naturally. One day, sitting at home, I happened to watch a documentary from The Economist on a digital nomad couple. And, aside from wanting to also be a digital nomad, I also started thinking about how some of the different employment and labor legislation would apply to this employee that's jumping from jurisdiction to jurisdiction, and more importantly, outside of the jurisdiction of their employer. And so I had actually reached out to the editor-in-chief of Canadian Lawyer magazine. I asked him if I could write an article about some of the legal issues affecting these digital nomads. And once he said yes, the article was written. And before I knew it, I sort of unlocked this diverse community of individuals that were really pushing for remote work and trying to empower the workforce to go remote. And I feel like once I was sort of in it, there was no going back. It turned into drafting remote employment agreements, independent contractor agreements, health and safety checklists, employment handbooks, remote work policies, and just sort of working with a lot of these global organizations to help them legally and compliantly go remote.
Okay. So now you're running Remote Law Canada, right? You provide legal advice to companies on remote work. So what are some of the most, I guess, common misconceptions that companies have about remote work, and how do you help them overcome these misconceptions, right? Maybe a few words from legal perspective of this.
Yeah, absolutely. So, I would say that the first misconception that people tend to have is that remote work definitely happens at home. Remote work is taking place anytime you're working outside of the jurisdiction of your employer, but also the employer's head office or main office. So, prior to the COVID-19 pandemic, remote work was happening when you were sending emails in a cab on your way to work or on your way to a meeting. Remote work was happening when you were sitting in the airport and sending emails from your device. And so, as a common misconception, I think that employers can sort of safeguard themselves from ending up in one of these situations where remote work is happening and they're not aware that it's happening. And then all of a sudden you're in a liability scenario. So for example, what happens when you're sending an email in the cab on your way to work and the cab gets into a car accident? Is the worker covered by the employer's insurance policy? Well, one of the ways that you can sort of address that is by working with the insurer or having the employee provide some input with respect to what hours they'll be working, where they'll be working from, and perhaps some policies and procedures about when you can complete your work and when you can't. For example, when you're in a cab. So, although the misconceptions are there with respect to where the employee is working from, some of the ways to deal with that would be definitely having the correct policies and procedures in place and working with your employee to ensure that you're aware of where they are and when they're working. Another common misconception tends to be that employees are not productive when they're working remotely, or the employer can't monitor them or monitor their productivity when they're working remotely. So, the easiest way to deal with that would be to quantify objectives, monitor their output. If you're working asynchronously, then develop some sort of async models or policies and procedures for getting the work done. I think that, we were talking about it earlier, but this global shift towards remote work has sort of two camps. You've got the camp that is really supportive and really encouraging flexible, hybrid, and remote work models, and you've got the camp that is totally against it. And so when you're dealing with the camp that's totally against it, unfortunately, one of the biggest misconceptions that they tend to sort of thrive on is that employees will not be productive when they're working from home. I think we've seen that remote work has a number of benefits, one of which is definitely reduced overhead and other real estate fees associated with operating a larger office. And so once you can sort of help employees over that hump with respect to employee productivity, you can probably be in a situation where you can encourage more remote work and have better remote work taking place at the organization. The third misconception, and I was thinking about this, is probably that employers or this global shift towards remote work tends to think that it's a one size fits all approach. Unfortunately, it's not. So different organizations will have different work output processes as well as different objectives. And so you need to model your remote workspace off of what the company's goals are, whether that's certain metrics that they've got or certain productivity goals that they've got. And so that's on the larger employer organization scale. When you actually reduce it and you start thinking about only the employee, it's also not a one size fits all approach. So for example, if an employee that is in office is suffering from a mental or physical impairment, how could you meet your duty to accommodate by perhaps allowing them to work remotely? And then if you've got all of your employees working from home, how can you again meet your duty to accommodate for employees that have got certain back issues? So can you help them with setting up the ergonomics of their space so that they're successful? And so although, it's definitely to be assessed from a company-wide perspective, how can remote work well? It also needs to be assessed from an individual employee perspective. And so it's extremely important to sort of individualize those needs, as well as, use the proper comprehensive legal documents and concrete procedures to deal with some of those scenarios.
Okay, sounds good. And speaking about some global trends, right? So, for example, as I told you, we help tech companies to hire guys in 10 plus countries, right? And we see some local changes in terms of their this employment law, right? So, from your perspective, how is this current trend of remote work currently impacting employment laws and regulations in different countries, and what do companies need to be aware of as they navigate these changes?
So, obviously the global shift towards remote work affects employment laws and regulations in various ways. Employment law tends to be very localized, and so do tax obligations, for example. And so when you're thinking about employment laws and tax obligations, it's really important to become familiar with what those local laws are and what those tax obligations are in various jurisdictions, and definitely where the employee is domiciled. So, we cannot overstress the importance of working with local legal counsel to familiarize yourself with which employment laws apply and which regulations apply. It's also important, for example, to be aware of data protections when you're working and you're sharing information across borders. So, using encryption and VPNs and things like that will help to protect you. But with respect to employment laws and regulations in particular, it's especially important to be aware of what, for example, termination and severance requirements are for the employee in that jurisdiction, what your accommodation requirements are. So we already touched on that a little bit, but if you've got certain duties to accommodate, what human rights legislation do those duties fall under? And how can you familiarize yourself with those requirements? Same thing goes for occupational safety. So when you've got employees that are working from different jurisdictions, you have to be aware of certain requirements to keep a safe and healthy workspace. Of course, that definition was broadened in COVID-19, but that also relates to having a safe space. For example, at Remote Law, we have a health and safety checklist that we attach to every employment agreement. In that health and safety checklist, it specifically asks employees, is your space free and clear of trip hazards? The reason it asks that is to avoid a short-term disability claim. Is it away from stovetops? Because you have a lot of employees that are working in small studio apartments that are in their kitchen and they're sitting on a kitchen counter and that's where they're completing their workspace. How is the data protected in the workspace that you're using? So really, it all just comes down to drafting some of those core and comprehensive documents and familiarizing yourself with local employment legislation. You know, it is especially important, I think, to be familiar with the way that the employment relationship is treated in the jurisdiction that the employee is working. And the only way to be aware of that is really to consult with local legal counsel.
Okay, got it. And you started with this. You mentioned that your journey to this remote work started with digital nomads, right? So, I guess it was in one of your posts or article, you kind of encouraged nomads to work as independent contractors, right? To have this freedom to choose their work location, right? So with that, what are some of the unique legal challenges that employers face with digital nomads, right? Such as tax codes and information security. You mentioned this, I guess, but maybe we can go a bit deeper.
So the independent contractor versus employee relationship is probably the most challenging issue when dealing with some of these global distributed workforces. It really, really is the most challenging, I think, over and above tax obligations, because tax obligations are very specific and it's not difficult to figure out what they are in different jurisdictions. When you're dealing with an independent contractor versus employee relationship, the issue is the courts are not concerned with and actually don't take into account what the agreement says. So stamping a title on there that says independent contractor agreement is not good enough. It's really about whether the factors that are alive and well in this relationship demonstrate that it's an independent contractor relationship or an employee-employer relationship. So, for example, in Canada, the independent contractor would have the right to hire and fire their own employees. They would provide the tools and all of the equipment. So the minute that, for example, I see that an employer has provided a laptop to an independent contractor, that's an employer-employee relationship. They set their work hours. That's another big one. So the minute that the employer says, well, you're going to work from 9 to 5, but you're an independent contractor, absolutely not. That's an employer-employee relationship. So it's really just about becoming familiar with what the factors are that would demonstrate either relationship. And, you know, once you're familiar with that, you can sort of go from there. Now, one of the ways that I suggest employers try to avoid some liability here, if you know they're sort of unsure and they're in this gray area when they're trying to decide whether they're going to hire independent contractor or employee and which one the courts will interpret the relationship to be, is to get input from the individual themselves. So, for example, I just had a client yesterday, and they had me draft an agreement for a former employee who's now going to become an independent contractor. The independent contractor was actually going to work with an employer of record, and the employer of record was going to contract out this former employee, now independent contractor, to my client. The client wanted to actually impose a penalty for early termination, as well as have an agreement between itself and the individual who was an employee of the EOR. I actually told them not to have an agreement between themselves and the individual because, again, providing any sort of input on how that individual is going to complete their work would demonstrate that it's an employer-employee relationship. So the only agreement should be between the third-party client and the employer of record. Leave any agreement with the individual up to the employer of record. And then going back to what I was mentioning about providing input to stop some liability situations, you know, I asked that the employee actually provide a statement in writing that it was choosing to end the employment relationship and to become an independent contractor. So the minute that the employee/independent contractor recognizes and acknowledges the relationship that they're in, it will really help you in the future if somebody tries to challenge that relationship.
Okay. So your advice is just to avoid any misclassification, right? You have to be aware of local criteria for contractors and for employees, right? That's your
Absolutely.
advice. And the only way how you can do this is just to find local lawyer, employment, who is just expert in that, right? And just work with that guy, right?
Yeah, and it's also about possibly having templated agreements. So, we provide agreements to our clients that, for
Mm-hmm.
example, if you want to hire in Canada or you want to hire from the US, here's an agreement that you're going to use for
Okay.
every employee or independent contractor you're going to hire in that jurisdiction.
Mm-hmm. Mm-hmm. And speaking about employer of record, right? You touched this. When it comes to contracting services provided by employer of record providers, right? Do they truly offer any compliance protection, or like you said, are they just primarily serving as a friendly payroll solution with some standardized agreements, template agreements, and with super minimal guarantees from their side? What is your vision of that?
So, a common misconception is that the EOR, it will not provide some of those compliance protections, and they're really just there for payroll purposes. And so a lot of organizations, and I saw this when I was at Running Remote, think that the utility of employers of record are limited. One thing that we're not discussing whatsoever is that the minute you've got an employer of record, you as the third party client are essentially significantly protecting yourself from any employment law liabilities. So I think that they can be extremely effective in sort of an incidental way, just by having them on an agreement stating that they're an employer. You're already protecting yourself as the client from any termination requirements, any certain tax obligations, benefit requirements, and things like that. So I'll give you an example. We did have a large employer of record that came to us after the employee had filed a lawsuit for wrongful termination. The employer of record was in fact on the hook for a significant amount of money, upwards of $200,000, because the law in Ontario states that when an employee is fired on a fixed term contract, so the contract was to end, let's say December of X year, but it ended in February of the same year, the employer actually has to pay out the balance of the contract. So not 1 week per year of service, not 2 weeks. It's a fixed term contract, then they're paying out the balance. So the balance was somewhere around $200,000. The employer of record could not even challenge the situation and try to offload some of that liability to the third party client, who is in fact the person that terminated the employee. And the employer of record was on the hook for this large severance requirement. So in a situation like that, employers of record are very useful, because the third party, although they shouldn't have, and now we're working with the employer of record to protect themselves from a similar situation in the future, the third party just said, we don't need you anymore. They washed their hands clean of this employee, and then the employee was now suing the employer of record. So there are certain advantages that simply come as incidental to hiring this employer of record, and that's having this employment agreement between them and the employee. But as a whole, I would say that if you are shopping for employers of record, it's really important to find some that have the relevant expertise and work with the correct legal counsel and have legal counsel to ensure that they are complying with their obligations in whichever jurisdiction you're hiring from.
Yeah, and speaking of that, a lot of employer of record providers, they do not even have their local entities in different countries. They rely on local partners, right? So in your view, is it suitable for a company hiring remote workers to delegate their legal employment relationship to a third party that effectively employs the individual on their behalf? But it's not even employer of record. It's like some local partner in Colombia who are just hiring your guy. I mean, what is your perspective on this?
So, first of all, they shouldn't be doing that. I think, it's
But they're doing it. Everyone,
yeah,
every single employer of record, they have some partners in some specific country where they do not have entity, but they're covered this country. They promote it from marketing perspective and saying that we have like a entity there, but in fact they don't. They just rely on some local partner.
Now they could technically rely on a local department or any local entity that they're using as the, let's say, employer literally of record, so the employer on paper.
Right.
But that entity is the one that's going to be responsible for any legal obligations under any employment standards legislation. So although it's permissible, the employer of record perhaps needs to be weary of, in a situation where the employee is all of a sudden suing the employer of record, what is going to happen between in their relationship with this sort of third party, partner that they're using and themselves? Who is going to take on the liability for that lawsuit? And so the law would say it's going to be that local entity. And so has the employer of record contemplated that, and has that local entity contemplated that? And so that's something to think about. But at the end of the day, it's really going to be who is responsible for any breach of any legislation, regulation, policy, procedure that happens by that employee or by that employer. Who is responsible? Which court is the competent court jurisdiction? And so, although they are operating this way, unless they've sort of safeguarded themselves in having a comprehensive agreement that truly sets out who's responsible in any given situation where there is a breach, we could end up in a situation where all of a sudden it's employer of record versus third party versus the employee, and whole thing's going to go up in flames.
And we have our own entities in Latin America and in Europe, in some European countries as well. And what we found out that some of those countries, in fact most of them, from legal perspective, they do not kind of recognize employer of record as a service, right? So they do not have this kind of entity in their employment law, right? So from your perspective, what potential risks may arise from using an employer of record provider for employees in countries where this employer of record simply is not kind of recognized as an entity, or as a services?
So at the outset, we also do not have employers of record that are
in Canada,
recognized by legislation. But the moral of the story is an employer is an employer. So whoever in that situation, in the event of a breach, is going to be seen or interpreted as the employer is the one that's going to sort of have all of these obligations. So again, going back to my example of the agreement I was working on yesterday, one of the ways to prevent this situation and to hold the employer of record to account is ensuring that the employer of record is the only entity that has an agreement with that employee, nobody else. That, in a situation where there is a breach, would demonstrate that that is the employer and that is who is responsible for any breach of this relationship, whether it's a termination, whether it's a human rights claim, or what have you. So if you're in a situation where employers of record are not necessarily recognized, then you need to take a look at what the employment legislation says about who is the employer. And from there, you sort of dilute, and you keep going until you figure out who's responsible for any breach. And so, although, for example, in Canada, we don't recognize employers of record, it really just comes down to who is responsible for this relationship. And when an employee is in a situation to sue, they are going to sue someone. And so as an entity that is using, or an organization that's using an employer of record, you just want to ensure that the employer of record at the end of it all is going to be responsible for any employment law requirements.
And from your perspective, do you think we need some additional regulations in terms of employer of record as a service, right, in different countries, or it's not really necessary?
I think that it would take a very long time for the law to catch up to bring us to a situation where employers of record would be legally recognized. I think until that happens, the model is attractive and something that has quite a lot of potential.
Right.
But in terms of regulations or legislation specifically dealing with employers of record, I don't think that's the starting point. I think the starting point is legislation and regulations that deal with digital nomad work. And so once you have regulated that type of employee, you're also, again, putting some of the liability onto the employee in the same way that I'd said, employee input is required so that you're protecting yourself from a trip and fall or those types of situations. So the minute that you've sort of regularized and standardized this employee in the same way that in-office employees right now are globally recognized through legislation, but for example, even in Canada, we just had a significant strike by government workers that just ended because remote workers are not recognized in employment legislation. And so there was a very large strike to have just the words remote work included in our legislation so that that type of employee could be offered the same protections as in-office employees. And so I really think that it is not about sort of recognizing and legislating these employers of record. It's really about recognizing and legislating these digital nomads, because once that's done, the employers of record or the employer in general will have a method for dealing with this type of worker.
Okay, that's a good one. I agree with you. So, and probably the last question from my side, as a global hiring expert, as an expert in remote work, right? Can you share maybe 3 pieces of advice for companies who are just aiming to hire top talent from various countries, but they just at the beginning of this process?
So do it. I think, as you know, I'm definitely a advocate for remote work. And so I think it's extremely important to promote it and to also help enable companies across the globe to hire top talent from different localities. But, some of my top tips as this employment lawyer would obviously be to research the local employment laws and regulations to make sure that you're compliant. And, to determine whether you should hire locally or through an EOR, or how you should sort of treat this employment relationship. I tend to be a stickler about occupational health and safety. So, really ensuring that you've set out the requirements of the workspace so that you can avoid some short-term disability, long-term disability, workers' compensation claims. So, we had a case in Canada where an employee that was working for Air Canada had actually fallen down the stairs during her lunch break. When she tried to claim workers' compensation, Air Canada said she wasn't eligible, and a Quebec judge actually came back and said, no, she is eligible because you mandated her lunch hour. And so again, having this health and safety checklist that says, I'm working in a safe space would sort of help offload some of that responsibility onto the employee. And, it's especially important when you're dealing with workers' compensation, short-term disability, long-term disability. So, for example, contact your local insurer to ask them some of these questions. If this happens when my employee is working in a co-working space, if this happens when my employee is sending an email from the airport, are they covered by our policy, and how can I make sure they're covered by our policy? And then, it's really just about having extremely comprehensive and specific agreements. So we have remote employment agreements, not a general employment agreement, a remote employment agreement that sort of addresses a lot of these situations where it's, things are different. Data protection is different. Privacy is different. You have people that are working from home or working from co-working spaces that would have much higher requirements in terms of protecting data. So just ensuring that you have very comprehensive policies is extremely important. And I think it's, as long as with the employees themselves, you're setting clear expectations and you're communicating clearly, the relationship can thrive. But we are all about detail. So just ensuring that, you've got the proper policies and procedures in place. You're working with the employee on a regular basis to figure out, what their output requirements are. what tools they need to use to achieve those output requirements, what sort of communication models they have to use, that they have to incorporate to ensure that they're meeting those requirements is important.
Okay, sounds good. Yeah, I guess we're good. So thanks, Tara, for sharing your insights on employer of record models and models of how you can hire from globally, right? And for challenges and obstacles of this global hiring. So yeah, thanks a lot for your time. I appreciate it.
Thank you. It was fun.
Thank you.